Hello and welcome to the Defence Rests. Today's video we are going to address Tyrone Tucker and the Treehouse murder case updates. We have documents to go through. We have the prosecutor losing his cool. We have motions to go through. We have public defender issues to discuss, and we have his plan of attack so far and moving forward. And the best part about it is we're going to hear it from his own mouth. So don't go anywhere.
Served in an honest fight, true crime tales till the verdict's right, solving more than just trivial quests, where sentences rule at the defense rests.
All right, welcome back. Let's get into it, shall we? So if you're new here and you haven't heard about the Treehouse murder case and Franklin Tyrone Tucker, I'll do a quick overview for you. Hello, chat. Welcome, everybody. Hey, Gary. How are you? Hey, Tanya. It's a minute late. How rude. Miss Goose. Sorry, I was putting on the lippy. All right, so we've got a lot to go through. So back in 2017, Franklin Tyrone Tucker was charged with the unaliving of Matthew Bonnet. Now, this transpired in what was called the Treehouse at the time. So it's good morning, Kelly. It was a dwelling above a trailer park in the Florida Keys and in Key West. And Matthew Bonnet was the landlord of said trailer park and treehouse. Now, there was a lady living in this treehouse that wasn't really a proper dwelling. It had no water or electricity or anything of the sort. And her name was Paula Belmont, and it became known as a place of ill repute, basically. There was allegedly, drug dealings and other stuff going on there. So, in November 2017, two masked assailants attempted to rob Paula and the gentleman that she had there at the time, Roger Ragu, and took off with some money and some drugs. Now, as they were leaving, Matthew Bonnet came up to see what all the commotion was about and encountered these assailants and was unfortunately stabbed to death. Now, Tyrone Tucker comes into it in that he was in the wrong place at the wrong time more than anything. There is a multitude of evidence and footage and interviews all on his YouTube site, which is free, Franklin Tucker. And in those videos, the police actually had the two suspects nailed down pretty much that night, those being John Travis Johnson and Rory Wilson. Now, the following day, because they put these two people under, sorry, yes, I mispronounce it every time, Gary, Roger Raggett, I think it is. Good morning, Regina. Lovely to have you here. What was I saying? Yes, so they had these two co-defendants under surveillance, and the following morning, Tyrone went down to top up his mobile phone, prepaid mobile phone, with Rory Wilson, who was living with at the time and became a person of interest, and the chief of the police, Penny Phelps, at the time, decided to look into him, found a photo of him on Facebook that he was dressed up in a Halloween costume with a fake knife, and decided that, okay, we're going to bring him in for questioning, and it went downhill from there. There is absolutely no physical evidence whatsoever against this gentleman. He has spent 2 years in jail already. He has had his first trial as a pro se defendant, meaning he defended himself back in January. That was a mistrial, and he is now facing second trial that was due to start on the 9th of September. But we have some developments there, which I will get to, so don't go anywhere. Yes, no physical evidence whatsoever, no DNA on the knife, no DNA in the getaway car, no the victims that survived, Paula, who actually ended up with quite a nasty cut on her throat because they were held at knife point, actually testified in Tyrone's defence. So why a victim of a knife attack would testify against the alleged defendant, she had nothing to gain from that. So the there is quite a lot of allegations of corruption and evidence tampering and the rest of it. There is a whole playlist you can go through on the channel, but there is a multitude of evidence out there. So if you'd like to look up any further details for yourself, and make yourself more familiar before the next trial starts, please feel free. But today is an update as to where we're at now and where we're headed. So we'll start off with some documents that have been dropped on the Monroe County Sheriff's Office. You like my telephone? It's a ripper, isn't it? They're not cheap anymore. I had to hunt for that. Cool. It normally sits in my bedroom, but I got it out when I did the stream with Heather. Right, so let us have a look at this, shall we? We'll go to this one. Nope, that's the wrong one. How about we go to that one? That's better. All right. Now I'll zoom in. Now, as at the moment, Ty has been reapprehended and is in Monroe County Detention Centre as we speak, awaiting trial. So he's having quite a few issues with being able to represent himself, given the limitations on his, that he's able to have access to. So let me just get rid of this because it's right in the way. There we go. All right. So he writes a letter to the clerk of courts, to whom it may concern. My name is Franklin Tyrone Tucker, and I am a pro se inmate who needs to get ready to go back to trial very soon. I'm writing the clerk's office because during my first trial, I was not incarcerated and could request the clerk's office to issue subpoenas through the e-file system. There was a very nice supervisor who helped me to make sure I got my subpoenas for trial last time. Her name was Katie. Hopefully, she or someone else there can tell me how to request subpoenas for my witnesses now that I'm in jail. Do I have a subpoena for each witness for you to issue, or just give you the info with the date, time to appear and have you fill out the subpoena? If someone could get back to me with a process, that would be great. Thanks, Franklin Tucker. So that's how limited he is to what he can do. And this was the response. Good afternoon, Mr. Tucker. We are happy to assist you with the service of your subpoenas. We will need you to send us the drafted subpoenas, and then we'll stamp them and send them, the local subpoenas, to Monroe County Sheriff's Office for service. Any non-local subpoenas will be returned to you, in which you will need to mail them out. Please let me know if you have any questions or concerns, and I'll do my best to assist you in the process. Lovely. Thanks, Stephanie. Good job. What a great help you are. Now, let's go back. Oop. We've got some more documents since then. I couldn't save them in the right order, there it is. Go back. All right. So the next motion we have, Ty has put in for a motion to disqualify Judge Morgan. This cause is before the court on the defendant's verified motion to disqualify the judge. Oh, this is the response. Sorry. Ignore that one. Should have known because it's not in his handwriting. Come on, where's my arrow? Yeah. Get down out of there. Motion to, where did I save it? Nope. Oh, crap. I don't think I did. Anyway, he put forward a motion to disqualify Judge Morgan. And I really need to read that because it is quite detailed. Or is this it? Oh dear. I know, I was so organised. It's always the way. Why didn't it save there? I don't get it. All right, I'm going to have to get onto the site and find it because I just can't have that. Good morning, Bite Me. Good morning, Christine. Yes, I thought I had saved them all the documents, and I'm missing the main one that I really, really wanted. So just give me a moment and I will get onto this. It only takes a second. Luckily, I've got a very fast computer for once in my life. And it it pretty much searches itself on this site now because I've typed it in that many times that it almost pre-fills it for me. So that's a bonus. All right, criminal records. Franklin. Tucker. Okie dokie. Come on. Today. Come on. Thank y'all. That would be that one. And we go down to the docket events. So he has actually submitted quite a few motions, which we will go through. But this one is quite important because it's very detailed and it's important that you understand where he's coming from. So, is it that one? No, that's the denial. He's also put in a motion for change of address, like change of venue, and he's put in a motion for continuance. And of course, it's on the next page, isn't it? Have a breath, Jodie. It's not like it's nearly midnight in Melbourne. Hopefully it's very nice weather over in the US where you are. It's been a mild winter actually over here, which I don't know if that's a good thing or a bad thing. Okay, motion to disqualify. Here we go. All right, now I'm going to have to share that page and not that one. which I can do. I might not be all that IT savvy, but I will get there in the end. All right. Okay. Share screen. Okay, here we go. Let me make it a full screen. If I can. Bring it in a bit more. No, I can't do it on that page. All right. I'm going to have to deal with that. Sorry. That is the best what I can do with this one. That's going to be difficult because it's on the same bloody page. I'll move that up there. Ah, get up there. Up. I can't full page it. All right, here we go. Hopefully you can read that. Motion to disqualify comes now. Pro se defendant Franklin Tyrone Tucker moves this court to enter its order disqualifying himself as judge in the above styled cause pursuant to Florida Statute Section 38.10 and Rule 7.330 of the Rules of Judicial Administration, and as grounds therefore states as follows. Oh no, I'm missing chat. Sorry. Oh, thanks, Christine. I know I found it. I just don't. I've saved it and I've probably put it into a completely different folder in my rush. And I was so organised, Kelly. I thought I did have them all in a row, and I apologise. I'm sorry. Yes, I did, and I'll be playing some of that audio shortly. So, all right. Because they do discuss all of this, and it's good to hear it coming from Ty's actual mouth himself. So, he's got quite a bit. It's very interesting. So, Franklin Tyrone Tucker is the defendant in the above mentioned case and therefore a party thereto. The defendant believes he will not receive a fair trial in the above stated cause because of specifically described prejudice and bias of Judge James Morgan, first discovered at court hearings held on August 2nd, 2024. Now, we're only reading this stuff that's released on the clerk's office because since he was rearrested back in April, Judge Morgan has denied access to the courtroom for the media. So we're only seeing snippets. And as you'll hear from Ty, the docket isn't really a good reflection, apparently, of what is happening and what is going on. So this hearing on the 2nd of August, no one was there to witness. So, during a hearing on the motion to discuss with prejudice filed by the defence, alleging that the state had committed fraud upon the court by lying to the jury at the defendant's first trial, Judge Morgan chose not to view the evidence cited by the defence, which showed the entire incident. Instead, he allowed the same prosecutors to orally recount their versions of events, which then they lied about again. When the defendant requested the judge to review the videos to show that they were again lying, the judge refused. His excuse was, in situations like these, especially with a previous trial, sometimes he won't watch the video so he can hear what's said, putting himself into the mindset of the juror, so he can make assumptions as they would. This is a capital case, and the defendant feels he's lucky he wasn't convicted to a life sentence based on those lies. So the fact the judge would again turn a blind eye to the state's dishonesty and instead make assumptions based on what he imagined happened is more than enough to warrant a defendant's fear that he will not get a fair trial. Hey, Adair. Good evening over here. Good afternoon, I believe, for you. Great to have you here. Thank you. On the same date, during a hearing for a motion in limine filed by the state to prevent the defence from any mention of evidence. Oh, just for those latecomers, we are going through Tyrone Tucker's motion to disqualify Judge Morgan and some other motions that he has recently filed. And then we're going to listen to his phone call live. Judge Morgan again failed to look at any of the evidence and exhibits except for one. He did look at a section from a deposition by the lead detective on the case, Matthew Pitcher. In this section, he admits that physical evidence was tampered with and not discussed to the defence. Now, if you go onto my playlist, I have the full transcript of Matthew Pitcher's testimony or deposition. And if you go onto Justice is a Process YouTube channel, he has them all done using AI. So not only can you read it, but you can look at it and hear it as well. Hey, Udahef. Morning. Morning. I was halfway through a reply to you and I got distracted. Sorry, but I will reply. So, Judge Morgan also heard the state admit that a truck allegedly used in this robbery homicide was not impounded or preserved for defence inspection after the investigators searched for it for physical evidence, but not forensics. Judge Morgan also heard from State Minister Tom Walker, a former investigator for Internal Affairs, who had reported that approximately 244 pieces of evidence were mishandled, and that while he didn't think that any evidence had been mishandled to the point of tampering, he couldn't testify that evidence was not tampered with. That's a conundrum. Yes, you can stream. That's fine, darling. Yet with all of that information, Judge Morgan made the very dishonest statement for the record that the defence had not shown one scintilla of evidence that evidence had been tampered with or was potentially tampered with from his previous experience at trial. The defendant is also well aware of how lies told on the record by the judge can be extremely dangerous and have far-reaching consequences. Judge Morgan partially granted a motion for transcripts of a few hearings that had been requested by the defence as they are needed for trial and or to get relief from the 3rd District Court of Appeals. That's another thing that he's applied for. Now, Ty actually has had a bit of a win here with this application. I think Judge Morgan was a little bit taken aback, which is good. Get him on the back foot. While he has been made aware that the state still has not given, like Judge Morgan did not expect this this motion for dismissal at all. Took him completely by surprise. So, while he's been made aware that the state still has not given copies of the audio from the defendant's first trial to the defence, even after the defence has filed a demand for discovery for copies and trial scheduled to begin in approximately a month, he ordered that the audio from the hearings again be given to the state, who will then give copies to the defence. It should be noted the defence requested trial transcripts prior to the state, yet they were given copies months ago without giving copies to the defence. This puts the state in total control of when and if the defendant can receive relief from the higher court and when and if the defence will be able to have the audio transcribed in time to adequately prepare for trial. The defendant has never heard of items that had been requested by one party from the court being given to the opposing party for dissemination to the requesting parties, but this practice seems to go against any idea of fundamental fairness. Similar to the issues above, the defendant has told the court repeatedly that the defence hasn't been receiving any of the documents issued by the court since prior to Judge Morgan issuing an arrest warrant for the defendant on April 30th, 2024. There have been many documents issued by the court. He hasn't received any of the documents on file at the Monroe County Clerk's office at all, and we'll go into that. That explains my thumbnail with Joe Mansfield, the prosecutor, losing his shit. Where is it? There have been many documents issued by the court since that date, and the defence still has no copy of the arrest warrant or any other of those documents. When again the defendant asked Judge Morgan why he hasn't been receiving documents from the court. He told the defendant that he would not be receiving any documents from the court and that you will have to get them through discovery. The defendant is not even sure that that is legal, but it seems contrary to the entire idea of a fair trial. And it should be noted that Judge Morgan moved away from his seat with the microphone and spoke very quietly when he told that to the defendant. Now, Ty's got to be able to get onto the court documents, you need a computer, and you'll hear exactly what he's been given to use whilst he's incarcerated. The last of these causes from the August 2nd, 2024 date was again during the hearing on the state's motion in limine to prevent the defence from mentioning evidence tampering at the first hearing on the issue. The state claimed to have copies of videos the defence cited as being altered in any unaltered condition. The state was given a demand for discovery for the videos, and they claimed to have, prior to the hearing on August the 2nd, not only did the state fail to provide these copies in a fit of rage, Prosecutor Joseph Mansfield began yelling at the defendant, saying that he's not giving Mr. Tucker any more copies because the state has already given him, his former attorneys, multiple copies, and it's not his duty to keep giving copies to the defendant. The defence has never been given any copies of these videos, quite simply because they don't exist. However, the bigger issue is that Judge Morgan said absolutely nothing to the state for yelling at the defendant. Just let it, whatever. Blatantly saying he won't provide discovery materials in light of the judge's requests to the defendant to get even court documents from the state. The defendant has no choice but to believe this trial will be a mockery and a farce of justice. He starts quoting some case law here. The Florida Supreme Court has held the facts accused, more state law. Furthermore, the question of disqualification focuses on those matters from which a litigant may reasonably question a judge's impartiality rather than the court's own perception of its ability to act fairly and impartially. So more case law on why he should be. Whilst the original judge, the Honourable Mark H. Jones, did disqualify himself on January 29th, this Franklin Tyrone Tucker's initial motion to disqualify in this case. The motion has been made in good faith and signed here, there, in front of everybody. Okay, so motion to disqualify. That was that one. Now, I should be able to go back to all the ones that I saved properly and bring them up. So this is, now I'm not sharing the page, I'm looking at it, but you can't see a bloody thing. So, window, and I want this one. That one. Thank you. Lovely jubbly. All right, we're back. So these are the minutes of that, from that hearing. So the motion to disqualify, the motion was denied, but new trial dates have been provided. So the defendant requests a certificate to appeal decision or something to appeal decision, and the state did not object. Now, let's find that one. Okay. Let me exit this screen a sec. Oops. I got trigger happy. Now, how do I exit? Oh, there. The old finger got trigger happy there, sorry. So the next hearing on the docket for Ty is listed on the site as the 15th of October. And I believe that's a status hearing. So they have cancelled the trial that was supposed to start on the 9th of September. And I don't have any dates as yet. I assume that they will be readdressing quite a few things because, as I said, Ty has submitted a motion to change of venue. He's submitted, he's reopened complaints for Colleen Dunn, the district attorney. He's lodged a complaint against Judge Jones as well. And there's another lawsuit that he's filing against Dennis Ward for defamation as well. So he's got quite a few things under his belt. Yes, the next thing on the docket, Gabby, is the 15th of the 10th, but it says a hearing and docket sounding. But every time I've seen that on the docket, it's been a status hearing. So it would just be updating and seeing where everyone's at, and hopefully either setting a new trial date or relocating or addressing all of these motions, no doubt. So next up we have the motion for continuance. Add to stage. Yep, that's the right one. Woohoo! She got it. Motion for continuance. Hopefully you can read all that. Scrolling up. Ooh. Oh, I know why, because I've saved it individual pages. Jodie, you're an idiot. Okay, big enough for me, big enough for you. Thank you, Gabby. There is, yes, you can buy some merch at his store, Franklin Tucker, and, oh, that's his YouTube channel, sorry, YouTube channel link. And he also has, a merch website if you would like to support him, because he is a pro se defendant and he is supporting himself and doing his own defence. So feel free. Let me have a drink before I start this one. The old palate's a bit parched. Okay, comes now. Pro se defendant Franklin Tyrone Tucker moves this court to grant this motion to continue and reschedule the current date for trial. Call from September the 6th, 2024 to a future date agreeable by both parties. Despite the due diligence of the defence, there is no possible for the pro se defendant to get adequately prepared for trial by the current date. The ability to adequately prepare for trial is a fundamental component of due process that is guaranteed by the 5th and 14th Amendment of the United States Constitution. Under the 6th Amendment, see, this is how it was supposed to roll. It was supposed to just click, click, click across. Under the 6th Amendment, one of the standards for deciding if a defendant received effective assistance of counsel is whether or not the attorney adequately prepared for trial. The court issued a warrant for the pro se defendant's arrest on April 30th, and since his apparent arrest on May 3rd, the defendant has been incarcerated. The court acknowledged at a hearing held on June 28th the absolutely impossible task of preparing for trial while incarcerated. Whilst not an impossible task, the current situation of his incarceration has caused many issues that did not exist prior, which now require more time for the defence to adequately prepare. These would include A, having to write all court filings by hand and submit via US mail. B, having no access to the court docket or the Clerk of Courts of Florida e-file system. C, reliance on program services for copies, that's terrible copy, for copies of paperwork and case law, which at times have been lost or taken over a week to receive back. No access to the internet to conduct independent investigations, no ability to copy any electronic documents or files for exhibits, limited amount of postage provided which limits filings or alters filings times, God, that's terrible. Access is his access to discovery is already received by the state or any of the independent investigation files that were once available to the defence. I have no idea what that top line says. And I've got new glasses. Limited supplies such as pens, paper, and envelopes. Whilst the above, you like my little hand? Hello, Gabby. I changed it so that I could see it. I couldn't see the little arrow. Whilst the above I didn't even notice the hand had been. I'm not used to it. Whilst the above represent only some of the issues the defence must overcome in order to prepare for trial, the state has made it even more difficult by refusing to submit filings to the defence and refusing to honour demands for disorderly orders. Oh, Ty, I can't read your writing. I can't read it. From the court to provide files to the defence. Whilst the defence will be filing a motion to show cause for the state's discovery violations and failing to disclose orders from the court, this will again need more time. One of the specific things ordered by the court are the audio files from the first trial. Even if the state turned them over today, the defence would still not have time to have them transcribed for use in trial preparation or for impeachment materials, which by itself would be fundamentally unfair as the state already found time to get the transcripts they wanted. 10. Another issue causing delay that the court is aware of is the defendant has only recently received Indigenous status with the Clerk of Courts and will be required to go through the Judicial Administration Commission for expert witnesses he needs to for trial. Both with any transaction services of the first trial or other hearings needed for trial. Well, the defence has already sent away for a I have no idea if anyone can translate that. Oh, good morning, Bri. Hello. Oh, you work too hard. Bri. Hello, welcome. Maybe you can help me read this shit. I can't read his writing. Steve, come and help me. Oh, Lord, his writing is terrible. I cannot. Well, the defence, it's this one here, that bit there. While defence has already sent away for a, looks like jack pocket. The court is well aware it could take months for expert to be approved and the examinations necessary to provide their expert opinions at trial. As the court can see, there are far too many obstacles at this time for the court to expect the defence to be prepared and ready for trial by the current trial call date of September 6th. Well, we know that that's not going to happen now. Whilst the defence is sure the court's aware, we would be remiss if we didn't remind the court, that just because the pro se defendant chose to exercise his constitutional right to self-representation does not mean that he wanted his right to adequate trial preparation, and that doesn't mean that he waived his right to adequate trial preparation. That makes better sense. And that to deny him that right would result in a miscarriage of justice. Wherefore, the defence would request the court grant this motion for continuance and order the trial date be reset for a future date, which as we know, has changed. So the judge denied his order for disqualification. Oh, there you go. There's the docket. So that I printed off, took a picture of. So this one here is the original trial, and this is the next date, 15th of October. Right, so we're off there. Nope. Oh, lordy me, look at chat go. Wow. It's faster than a steaming bullet. No, a steaming bullet. It's after midnight, okay? Hey, Steve. There you go. There is Steve Justice Process's link to his YouTube channel. He is like the encyclopedia of all things Tyrone Tucker. So a jack packet. Is it a jack packet? Yeah. I don't know. I couldn't read it. Sorry. I tried. Hey, Flash. Welcome. How is you? And good to see you too, AJ. Sorry. Feels strange being up here without you. I'm all mild myself. How will I cope? Hey, Becca, how you going? It is a jack packet. Okay, cool. Thank you. And yes, my lovely co-partner, alternate juror, there is her website. Ah, thanks, Steve. Jack Packet, Justice Administration Commission. Okay, thank you. Ah, Bri came in second, but you were always there. You missed it by like that much. He's so clever. Sounded you didn't forget. Okay, cool. Awesome. Thank you. Right. Oh, look, and see, I'm sorry, you've just been upscaled in chat, Steve. Bry's come through with like the monologue. The Justice Administrative Commission is responsible for processing payments of attorney fees, court approved costs, and associated expenses in relation to private court appointed and Indigenous. There you go. There's the official. Thank you, Bry. Go to see. Yeah. Oh, have you? That's not good. Not good. You have to look after yourself, Flash. Oh, didn't fit into the one message, Bri. All right. So the next hearing is set, as I said, for the 15th, and it's a sounding hearing, which is basically just to check to see where things are. I thought so. That's good. Good, good. Yes, you need to look after yourself. Bri sandwich, she'll always. He wouldn't be a sandwich if he came on today. Would he be tops or bottoms? All right. So, where are we? We got any more documents that I had up there that I needed to go through? I don't think I did. Continuance, disqualifications, the docket. No. Okay. So, we get to the good bit. So, as I already said, Steve from Justice Process was lucky enough to get hold of Ty and speak to him directly on the phone last week, and asked him quite a few questions and went through all of these things that we've discussed as well as more. So I have created a little video just to show you exactly what they talked about, so you can hear it. To Sarah Boone now. Now, when should her trial start? It's that's October 2, isn't it? Yeah. All right. So, this is from Justice is a Process. Look at that beautiful face. Even had a shave for the phone call. So, yes, Steve spoke with Ty last week, and I will put up his. Where are we? I know you're there. Oh, Jody, you idiot. Where did it go? I've lost it now. There it is. Okay. So this is the link to Steve's YouTube channel, and you can see the original footage. I did cut out a couple of little bits and pieces. There was a couple of other names that Ty mentioned of other cases that he'd been talking to, a fellow inmates. So there is a little bit of editing that I've done to it to cut it down a little bit. But if you wanted to see the full phone call, head on over to Justice is a Process on that channel right there. And he has got so much more stuff over there as well. He's got lots of all the audio transcripts so that you can listen and read along. And he's got some more exciting stuff. I think he's got Rory's trial coming up as well. So, yes, he is all things Tyrone Tucker. So let's have a listen. It's actually nice to hear Ty's voice.
Because, man, look, the way things went this week are great.
Now, tell me if you can hear that properly.
They're looking at the docket, man. The docket doesn't exactly reflect what's been going on. You know
Okay.
what I'm saying? Not that I can see it very much. I mean, I have people who will send me pictures of it and that kind of thing. But at the same time, man, it's not like I can just go and check anytime I want to.
Let's see here. Monroe.
Because, man, Judge Morgan, man, hated that shit. He had no idea it was coming, right? Because they pulled me in. They gave me like a half hour, man. I mean, like literally, they were like, Tucker, get up, you're going to court, right?
Wow.
And I'm like, okay, fine. And this is supposed to make up for the one that he canceled on
right, which was abruptly canceled, right?
Right, exactly. It was canceled. Like, I mean, literally, I was supposed to be on my way on transport, man. They just called me, called up the guard, and they were like, "Tell him he's not going. Tell him he needs to call his lawyer with the line, whatever, whatever, man." But the thing is okay. So they pulled me up, man. They pulled me into court, and I hit him with the motion to dismiss. I mean, not motion to dismiss, the motion to disqualify, right? And he sat there for like 45 minutes going over this thing. He probably read it about 5-6 times, right? And he's like sitting there, he's like, that kind of thing.
Right.
Like, okay, but eventually he denies it, which I was expecting, right? So he goes ahead and he denies it, but he denies it for being untimely, right? And the thing is, man, okay, you have 20 days, and man, from the time of discovery, from the time you discover, the last showing of prejudice, you know what I'm saying?
Right.
And so anyway, so I go ahead and it's on.
I can hear your kids running around in the background. Oh, and if nobody knows, Steve and his lovely wife had another baby boy. Is it 2 weeks ago now, Steve? Carson? And I hope they're all doing well. Sending our love.
Was it August 2nd was when I did the discovery when we had our last hearing, right? So anyway, so I still had 2 days left on the clock, and he's trying to rule it as untimely, right? So the third DCA is going to give it to me.
Right.
He knows this. Actually, he knows he's not going to be the judge, man, as soon as the third DCA gets a hold of it, right? So anyway, so what I did is I told him, I was like, well, Your Honor, I went ahead and assumed that you were going to make that decision. So I went ahead and filled out an application for a writ of prohibition against you, and I'll have that off to the third DCA immediately. And I think given the nature of the motion, we should take continuance until we get a ruling from the higher court, right? Which he laughed at me at first, and he was like, "Well, they get a lot of these from the 16th judicial, and it takes about 4 months." And I was like, "Well, that's fine with me, Your Honor. I got plenty I got to do. I've got a whole motion to change venue I'm working on, and I got experts I need to line up for trial, all kinds of things going on. So 4 months is fine with me." But then he turned to the prosecution, right? And he's like, he's expecting them to bail him out, right? He's like, "Well, does the state object?" And they're like, "No, we're fine with it." And he was stuck. So he was stuck. And he had to, he gave us till October 15th. But okay, on October 15th, all he's going to do is see if there's been a ruling from the higher court, right? We're not doing anything until we get a ruling from the higher court. Because if you read my motion to disqualify, it's pretty harsh.
Right. Yes, it is.
And that's only from one hearing. That's actually one day.
And it's pretty disturbing too with
for me the entire time.
with what you laid out in there. Yeah.
Yeah, I mean, look, man, he's okay. Dude, he's keeping me from the court paperwork.
Right.
I can't even get the warrant, man, that got me in here.
Right.
I could have wrote, a writ for habeas a long time ago if I had that. But he's keeping me from the document.
Really?
See what I'm saying?
Well, yeah, but how are you? Yeah, exactly. How are you supposed? I saw that in there because you asked him about the documents and you said he leaned away from the microphone and said you're not getting the documents from the court. Well, who are you supposed to get them from?
No, I'm not getting any of the court orders. I'm not getting any of the notices. Nothing.
Well,
and he told me I had to get it through discovery from the state.
No.
It's my state's job. I can even see what they're going to respond.
Well, there's
a job to give me the court documents.
And they have a requirement to give you these documents. I mean, that's a requirement to make you aware when a motion's filed and orders filed, and because you're the attorney of record, you have to have it.
But how am I supposed to file for relief if I can't get the documents to show the appeals court what's going on?
Right.
You know what I'm saying?
Mm-hmm.
So that's what his game has been. But see, that's where the motion to disqualify is different because, okay, by doing that, I'm in control of that because I'm the one who has the original motion. Right. Right? Right. So, and then, it was nothing for me to send it to the third DCA. All I had to do was write up the application for the writ. You know, and they're definitely going to throw him off this case. You know? So once he's done, by that time, okay, I'll have the motion for a change of venue. Right. So I'll get that one too. Right, because I have a conflict with every entity in their legal system.
Mm-hmm.
I've got complaints against them with every outside agency. I've got lawsuits going against them. It's not a question of whether or not I'm going to sue them. They know I'm suing them.
Mm-hmm.
Right? I shouldn't even be in this jail.
That's right.
I'm suing the sheriff. I'm suing the sheriff's department. Of course, they're going to make it so that I can't get what I need to prepare for trial. It's ridiculous to think they would.
Yep.
They want me to lose.
Exactly.
Okay. Because I went all the way to the sheriff with that one. That was funny too, because I actually had to, how you have to maximize out your grievances,
yes.
what I'm saying, before you can bring it into court.
Right.
And so I went all the way up to the sheriff, with these complaints. Look, they're trying to give me, this is what I get, man, to go pro se here, to fight a homicide case, right?
Right.
They give me 4 legal pads, 2 of the pencils, and 4.
I did have to laugh between Steve and Ty on the phone. It was like a competition who could get more airtime.
4 flex pens per month, man, to fight a homicide case.
Well, that's what?
That's what I get.
Well, how come then, and you need to raise this issue or look into it, but I mean, Sarah Boone is going.
I already did.
Did you?
Look, I already did. And not only that, I was actually going to do a motion for an ROR, man, based on these issues. Because,
right.
The bottom line is okay, yes, I waived my right to counsel, but that does not mean I waived, my right to effective assistance. It doesn't mean I waived my right to be able to prepare for trial.
Well, and you need to have a computer because there's electronic documents. I mean, there's videos and things that you need to be able to have access to. They need to provide you with a computer because you can't. The state doesn't get to see your work product.
They did budge on that, right? Yeah. They budged on that. I can go ahead and watch videos and I can watch audio. I think I get it for like 5 hours a week.
Oh, okay.
In my case, that ain't shit.
Right. Yeah, no.
The bottom line is, man, I can watch video and I can watch audio, but they won't let me copy it for exhibits.
Yep.
You know what I'm saying? It's ridiculous. I mean, dude, we have one pencil sharpener in the dorm. When that thing breaks, I'm screwed. You see what I'm saying?
Mm-hmm.
Even when I go to do my copies, man, look,
at least he sounds like he's in good spirits still.
Why do you think it takes me so long to put a motion in? First off, I have to handwrite the damn thing, right? And then I got to put in for copies, which can take a day or two, man, usually, right? And then I have to go ahead and submit it snail mail, right? Which takes about 10 days for it to reach the court.
We have the technology.
Before it shows up on the docket. It's about 10 days from the time
I don't know if I do.
to the time it shows up on the docket. And when you're talking about a 20-day limit on that motion to disqualify, that means
you have to do it on
immediately after I got back from the hearing.
Right, and you got to handwrite it, and you got to
the original video.
Wow.
Yeah, so it has not been easy, man. And man, look, he's been doing everything he can, man, to try and tie my hands behind my back. And man, the one thing about coming back here, I'll tell you what, man. Look, remember I told you, man, many times, man, I'm not by myself. I'm not alone.
Right.
And this has been quite the education, or re-education, I should say, of man.
of people that are
people they do this to.
right.
You know what I mean?
Well,
there's other people in here, exact same circumstance. You know, they're facing murder charges, and man, there's no evidence.
Yep, this needs attention. Now, I have a question for you. They claimed because this was covered in your motion. They claim they have body worn camera of Pitcher. Okay, and I've been through the depositions. I've been through. I mean, I went through Pitcher's deposition.
They have body worn camera of what?
Of Pitcher's body worn camera from Pitcher of Rory's missing 3.5 minutes.
Really?
Right. And man,
Really?
It doesn't exist. Right? Well,
for 7 years, I've never seen that.
yeah, but why were you? One of the things that stands out to me, because I was going through the depositions and recording them, your attorneys were questioning him, Pitcher, about that. So if Higgins doesn't have it, why would they be making an issue of it in a deposition about it not existing? So there's the evidence it doesn't exist. And then did they produce it? That's what I was going to ask. Did it ever get produced? Because they said they were going to produce it in the minutes. Did it ever come in? No.
And not only that, okay, if you read my motion to disqualify,
right.
Mansfield, the way he handled that,
he yelled at you in disrespect.
He lost his shit, right? He told me straight up, he's not going to give me, man, he's not going to give it to me.
Well,
he told me that flat out in court.
Well, you should be able.
You know? And I was like, and I asked for it specifically because I know they don't have it. Same thing with my uncut interview. They say they have a version of my interview that's uncut.
Right.
You know, and you and I both know that doesn't exist.
Exactly.
You know what I'm saying?
Well, hey, man. All right.
Sorry about that. Man.
No, that's okay, man.
They had to stop. You get 15 minutes a phone call, so we're on the second phone call now.
Oh yeah, there's. I know you. I know. Yeah, I know how that goes. So, yeah. So I guess we were talking about what were we talking about? I guess the situation with the.
Talking about the motion to disqualify.
Yeah.
Judge Morgan.
And then we were talking about the missing 3.5, the missing 3.5 minutes that you said they did not. They never. The states never produced it.
Chopped up video.
And it's chopped up video. And then the other thing too is you need to pursue, or have you pursued, and make sure that goes in as part of your attempt to. Are you trying to disqualify the prosecutor's office as well for their actions? I thought I saw that.
No, actually, man, that's going to be part of. Okay, a lot of people mistake what a change of venue actually is. People think, man, it's just moving a city.
Okay.
That's not what that is.
Okay.
Right. What the change of venue does is, man, okay, it's going to remove everything from this county and put it to another county.
Okay.
Which means I'm going to go to either Miami-Dade, or I'm going to go to Broward, or some other county.
Right.
Which means, okay, the prosecutor is no longer in
That
charge
would
of the
be
prosecution.
absolutely awesome.
Right? That's all done. And
Right.
Dennis Ward is done. Same thing with the judges here. They're done. You know, same thing with, man, the entire county, the entire case. I actually will be moved from this jail to a jail in whatever county it goes to.
Okay.
You see what I'm saying?
Yeah, gotcha.
So, it literally removes everything from this county and it moves it over to whatever other county. And I guarantee you, when it goes over there, they're going to look at this case. They're going to look at the history of this case. And, yeah, they're going to drop this case. I'd be 90% sure of that. You know what I'm saying?
That would be absolutely amazing.
They have no vested interest in it like they do down here.
Correct.
You know
so they're going to present it fairly without the BS. Right. Yep.
Right, exactly. Which means I'll tell you right now, man, if I get it out of this county, which, man, it's looking very, very good for me to do that, right?
Mm-hmm.
And actually, I kind of lucked out, man. It sucks being locked up, right? But in some ways, it's been a godsend because it's given me the evidence I need to go ahead and get that change of venue.
Right.
You see what I'm saying? So,
right.
Man, once it goes out of this county, hell, I'll tell you what, man, I might even take a lawyer again at that point.
Right,
you
right.
Well,
that was going to be one of the things I was going to ask you about. Was I know they appointed you a public defender, correct? Because that was kind of shady the way it looked like it happened.
That was a mistake, man. It was a mistake by the clerk's office, but they tried to. Right?
Well, Ty, was it a mistake?
I can barely read his writing. But what he was saying was that he said it sucks being in jail, but he said it was a bit of a godsend at the same time because it's given him the evidence he needed to be able to put in for a change of venue, which would then give him the ability of having a much fairer trial in another county. Yeah, so that's where he was going with that. The rest, can you hear it okay? Is it loud enough? Oh, sorry, that was bad pause too, Steve. Sorry.
Well, see, my thought on it was it was an attempt for them to, because my belief is Morgan's position,
Thank
Morgan's job is to essentially
you.
protect the record and create a record that you can't, if you get convicted, that there's going to be no appealable record. And one of the things,
He's definitely been messing with the record.
well, one of the things that I thought was going on here was is that they appointed you an attorney. See, what I think they were doing was they appointed you an attorney to get you to fire the attorney and then waive that as an issue, because one of the issues I saw coming in was they arrest you. You end up in a situation where you're now divorced. You're going through a divorce. You're unable to access funds, but you don't qualify for an attorney in that period of time. And therefore, it creates an issue down the road that they could say, like, what are they doing here? They bring you in, and then
Yeah, it's almost like they're 2 steps ahead of him and just cutting him off at the bloody knees every which way.
they're depriving you of supplies. They're depriving you of access to experts, basically because you can't get indigency at that point. So then they throw you this attorney on accident. So then you fire the attorney and it takes it away. And that's what I saw them kind of trying to play that game.
Well, I even tried to argue that in my arraignment, man. And man, the thing is my arraignment, if you want to call it that, man, it's not even an arraignment. I didn't pick up a new charge.
Right.
But when he put that $3.1 million bond on me,
how does he justify that?
Ridiculous.
My wife is divorcing me.
Yep.
And I was like, there's no way I'm coming up with $3.1
Right.
million.
How did he justify $3.1 million?
You guys know damn well, 8th Amendment to the Constitution of the United States, it goes ahead, excessive bond is the same as saying there is no bond.
Right.
So you made it so that, man, I couldn't get out. And you did it on purpose.
And not only that, but Florida.
They had me arrested on trumped-up charges. It was because I didn't even violate it. You didn't even read the violation. They say I showed up.
Yes, and you passed.
The violation is saying that I didn't appear.
But not only that, but Florida case law states specifically, if you would have had a contested that bond revocation is the absolute last thing, because bond is not meant as a punitive thing. It's meant to secure your.
No, it's
meant to secure you to come to court.
Violation in and of itself.
Yep.
That's a fifth and 14th Amendment.
And Florida case law is very clear on that aspect, at least from my layperson's perspective.
But the reason I didn't argue that, I actually was going to argue that. But you know what? I was like, no, Morgan's not going to give it to me.
Well, no, Morgan's not going to give you anything.
Actually, just out of curiosity, whilst I was watching another trial in Florida recently, they only had six jurors on the jury. And apparently, there's I'm not sure which part of Florida it applies to, but there is a change or an alteration in the amount of jurors. So they are having 6 jurors on a non-death penalty case, and then 12. There's a difference in the laws. So does anyone know if by chance Ty will be having 6 or 12 jurors at his next trial? 6 jurors, yeah, non-capital, but this is capital, isn't it? This is a capital case, yeah? So he'll be having 12. Is that correct? I think so. I think I'm right.
Yeah. No, Morgan's going to deny.
I'm like, you know what? I'm like, no, disqualify his ass.
But what you've got to do, Ty, is what you're doing with Morgan, because I believe Morgan, and he's done this from day one, when he got you to waive the speedy trial and he got you to do all this. I believe you've got to fight. Like, I know you said before previously, you're like, I'm not worried about appeals. In Morgan's case, you've got to assert every right you can. You've got to protect the record, and that's going to frustrate the guy. And
well, I mean, don't get me wrong, because you notice I'm going to the third.
Yeah, I'm ecstatic that when I heard that, because I was informed of that, and I said absolutely. Yep. Yes.
I'm gonna tell you right now, whoever the next judge is going to be.
Is it too loud, Gabby? I'll turn it down.
Absolutely.
I boosted it. Sorry.
And whoever it is, they're going to try and deny that change of venue.
Yep.
Right? And man, I'm going to have to
That
go
better?
back to the third DCA and get them to approve it.
Yep.
You know, that's how this is going to work.
Yep.
Right? thing is, man, you're absolutely correct, man. That record is important.
Yes.
And, that's why when he lied on the record, it's like, no, I know how dangerous that is.
Absolutely.
Speaking of which, since we're limited on time.
Yes.
Here's the other things I've been up to.
Okay.
I went ahead and I sent off a letter to the bar to try and reopen the complaint against Colleen Dunn because that's being closed out in September.
Mm-hmm.
I think I'm pretty sure Lauren and I don't talk at all really, but the last thing I said to her is I wanted her to go ahead and see if she could get it reopened, right?
Mm-hmm.
And the reason is she put a lot of work into it. It's to help other people. And,
right.
Straight up. I mean, they're going to go ahead and close it out forever. Come September, and she's the original complaint. So I'm hoping, and from what I've heard from Becca, she did go ahead and contact them and try and.
Oh, look who's famous.
So we went ahead and reopened the complaint against Dunn, and then I went ahead and the JQC, the Judicial Qualifications Commission, I actually sent away the complaint on Judge Jones. And all they should have to do is watch the trial.
Yep.
I mean,
well, have you also filed?
Should be thrown off the bench.
No, have you also filed a complaint against Alvarez and Mansfield for lying in their opening statement or closing argument? You cannot.
I can't.
Well, because they.
Okay.
Okay.
The way the bar works is
I think that's prosecutorial indemnity, isn't it?
Right. Well, I mean, but they lied to the court, which is a absolute issue. That what I mean is doing it in conjunction with throwing them off the case. Yeah, because you need to get them. You need to get them tossed out because it's. I mean, listen, Vinny Politan himself raised issue with their ethics when he said they lied, like they knowingly lied to the jury. Yes. Well, I'm just saying.
And then we were fighting about that in court. That was actually what we were fighting about before the motion disqualified.
Because that to me is going to be something that when they look at it.
Remember though, I don't have to worry about throwing them off.
Right? Okay.
Because if I get the change of venue, they're off anyway.
Right.
You know what I'm saying?
Well, I just mean it would.
They're done anyway. It doesn't matter. Then I can go ahead and do whatever I'm going to do.
Well, you may if you start to go after their bar card and just start filing stuff, it may make them back away and say, you know what, we just want out.
So I mentioned your name during the call, Becca.
And actually, here's the one I am doing, and I didn't get to this, is I did talk to Kara, right?
Okay.
And I'm trying to file a lawsuit against Dennis Ward,
okay,
the attorney.
Right, yeah, you definitely need to do that, yes.
And this is for defamation, right? This is for when they remember when they announced the retrial?
Yes.
And you can find it on Facebook, the thing where they announced the retrial, right? Well, he goes ahead and says, proof positive that I actually did this crime, right?
Right.
You can't do that.
No.
He doesn't, he's not allowed to do that. That's defamation all day,
right?
Well, the thing is, man, okay, he gets immunity for what he does as a prosecutor. He does not get immunity for going ahead and making, press releases to the public that are defaming me. He doesn't get immunity for that. So I'm trying to go ahead and get Kara, or if she doesn't want to take it, I'm going to get some other lawyer to go ahead and file suit against him. You know what I mean? Because, man, it's like, okay, he's the one who wants to burn me. It's not Alvarez and Mansfield.
Right.
I mean, they're the tools of, man, they're his tools that he's using, yes. But it's Dennis Ward all day. He's the one that, man, has been maliciously, man, just coming after me.
Yes.
Right? He's the one that wants to burn me. And, man, he's the one who's going to keep up with this crap. You know what I'm saying? So, okay, fine. I'll go ahead and start the lawsuit now because that's what he's afraid of, right? He thinks that if he convicts me, he's not going to get sued, which is stupid, right? He's done so much shit that, man, look, you're not getting out of getting sued, buddy. I hate to tell you this. You know what I'm saying? Even if you manage to convict me, civil rights violations, you know this as well as I do. 1983 lawsuits, it doesn't matter if they convicted me or not.
Right.
They still violate my civil rights.
Yep.
It doesn't make no difference.
That's right.
Right?
That's right.
So, I mean, it's all pointless, And, man, look, he's going to end up, man, you talk about somebody who cuts their nose to spite their face.
We're trying, Christine.
Because, look, man, this is all going to blow back on him hard now. You know what I mean? That's how good this week was. Because, man, by getting that motion disqualified to the third DCA, oh, yeah, now they're going to, man, go ahead and hammer Morgan. And as soon as he's off this case, guess where, man, I'm going with him? He's going
I hope you do because what Well, the fact that the way he revoked your bond, I mean, that should be looked into 100% because that was such an extreme move.
The history of just dude, the little bit he's been on this case, the few months he's been on this case, whatever, 6 months, 7 months he's been on this case. That's why I wrote that letter to him, right? I wrote that letter to him. I was like, man, you've been a bull in a china shop.
Yep.
You know what I'm saying? You're worse than Jones.
Yep.
And man, but not anywhere near as smart as Jones was.
Yep. Yep.
So, I mean, at least Jones tried to maintain, man, some illusion of, man, propriety.
Yep.
You know, this guy, man, doesn't even care.
Yep.
You know?
Well, that's what I mean. He is so outrageous that it's like he has gone to the point that it's like he's just blatant, and he literally believes it's like he just says, I don't. He really, I think, kind of is taking the belief that he doesn't think you have the ability to do things to bring it out. So he's just like, I can do whatever the hell I want. And I think he's been led maybe to believe that, and he's made a mistake.
Away with it so long. I mean, think about even the trial, man. They've been getting away with it so long, right? That even with national TV coverage there, and man, the whole world's seeing it through the internet, they still can't manage to do the right thing and actually do it the right way.
Yep.
You know what I'm saying?
Yep.
Now, that's one of two things. Either they're so used to doing it the wrong way, they don't know the right way anymore, or they just don't care because, man, they're like, screw all of you. Who cares what you think? We're going to do what we want.
Mm-hmm.
You know? Now, I don't know which it is, but both of those are sad and horrible.
Yes.
You know? And I'm sitting in a room, man, filled with 100 other guys, man, and let me tell you, they all come to me now. I mean, and Lord knows I'm the jailhouse lawyer to go to nowadays. You know what I'm saying?
I guarantee you are, man.
But, you know,
yeah.
But I mean, I'm like, what's the thing they got, right?
Right. No,
Let
absolutely.
me tell you, for 2 chips to the chip, man, I got you.
Yeah.
You know, but anyway, the bottom line is, though, man, one of the things I see in all these cases, right? One glaring hole in all of them, no evidence.
Mm-hmm.
You know, literally, almost every case I look at, man, that's the biggest problem. No evidence.
How many of them are using? You know? How many of them are attempting to use jailhouse snitches like they did with you? Because that was something that was a common.
They do that all the time.
I was going to say, yeah.
They do that all the time. It's common.
Yep,
it's
that's
common.
what I thought.
That's what I figured. Try another one with me.
Well, yeah, but Ty, they can't. Look, they might try, but how ridiculous would it be when you've been as vocal as you've been? Yeah, I mean that would be.
If they try, it's like, look, there's a million people who know about my case, man.
Yep.
Good luck with that.
No, I mean, listen.
But then here's the other problem, okay? Because man, here's what their whole play is, and this is why man getting a PD is so bad.
Right.
It's because literally, man. I mean, you're talking about, you know, the PDs might as well work for the state because man, they all want to leave you here as long as they possibly can and get you to take that plea deal. You know what I'm saying? That's what the deal is. You know, you've got people sitting in here on an open container for 6 months to a year.
Well, here's the thing, though, Ty. If you get a PD, right, you can there's a network of people out here. We can reach out to the PD. Like once you get a lawyer, I can reach out to that lawyer and say, hey, listen, I'm, you know, we want to talk. And Ty, you know,
the problem is you got to understand they're working against me.
Well,
they don't care what you guys have to say. You know what I'm saying? They would be working against me. I give up all my rights if I do that. Right? Well, if I go ahead and get a PD, I'm not in charge of the case anymore.
I understand.
Anyway,
yeah.
man.
I got you, man.
I haven't got enough on my phone time to keep going.
No, I got you.
I'll tell you what, we'll have to do this again.
Yes,
sometime
for certain.
Soon, you know?
Yep, absolutely.
And, tell everybody, give everybody my love. And,
I will.
You know, look, you know, it's looking a lot better than it was, man, not too long ago.
All right.
All right. The man or the men themselves. Whoa, there we go. Jody's back. So, there you go. You heard it from his mouth directly, from his lips to God. So, it sounds like the plan is that he's put in the motion to disqualify the judge, which was denied. He's now put in for a change of venue to get a fair trial to go to another county, which would then go under the jurisdiction of another district attorney and a different judge, and that would be a clean slate to start afresh because they don't have any of the same agenda that Mansfield and Alvarez have, and Dunn and Ward and the rest. So that would be absolutely amazing if he can achieve that. And I'm glad that the court has decided to grant some extra time for him to prepare for his defence because that's what he needs. So the motion is the judge, which is not. Yes, it was, and he's appealing it. Good eye. But the judge doesn't follow him if he goes to a different venue, does he? I don't believe. Is that correct? Are you going to speak to him this week, Christine? Are you? What's his favourite colour? Good on you, Gabby. So we await the next instalment on the 13th of October, which we won't hear anything about probably until the 15th, when they decide to eventually upload anything onto the Clerk of Courts. Unless anyone else. Okay, cool. Thank you. Unless anyone else speaks to him in the meantime, they can update me and let me know. That would be awesome. Christine, you've got my details if you want to reach out the next time you call. And hopefully Steve will be in touch again shortly with Ty as well, once he has some more info to give us. So yeah, he's been a busy boy, which is good, and he does sound like he's in fairly good spirits still, which is great. I know it was off the back of the win with the continuance, so hopefully he's still in high spirits. And I understand more now a bit why he didn't take the offer of the public defender, because in the situation that he's in, everyone appears to be against him. His trust issues would be huge, so I can totally understand that. Although, a lot of people believe that that's not in his best interests. Ty is his own man, and he makes his own choices, and he knows the consequences. He's very, very smart that way, and yeah, no one can defend you better than you can defend yourself, really, because you're the person that knows all about it. You know the truth, you know the information, and yeah, it's just a matter of the presentation of it. That's hopefully he gets his message across and everything gets dismissed. Hopefully we don't even get to trial. Hopefully it just gets dismissed and he gets acquitted. That would be just amazing. Because as we watched yesterday, there is so many people that have been wrongfully convicted and spent way too much time in jail, and he's already up to 2.5 years now. So, 1 day for an innocent man is 1 day too many, in my opinion. Oh, you're welcome, Kelly. You're welcome. Yes, thank you for hanging out with us. So Ty requested a continuance to appeal the decision on the motion to disqualify. Okay. So the judge has postponed the trial so far until the 15th or the 14th, and then reassess from there. So the Third District Court of Appeals, yes, they've got to wait for the decision from there before they can address anything else. Is that right? Yeah, I'm happy to wait, Becca. I did listen to other stuff, and I did read a lot more, but it gets all muddled in my head as to not the process, maybe it is the process. There's just so many things happening with him at the moment that the actual course of action is nothing that I actually understand. So, what did you laugh at, Gabby? Did you crop dust? I have tried because I am in Melbourne, to actually have my phone number, to verify my phone number, the actual place where you put your phone number won't allow me to put enough digits in to accept the international code. So I can't get the verification text to verify my account. I've got the account, I've got everything set up, and I cannot verify it because I can't get the text back. So yeah. Yeah, he said, I think he said you filed to reopen the complaint against Colleen Dunn, to reopen that case. Yeah, she's a piece of work, isn't she? Yeah, he talks so fast. He does. Anyway, so that's probably everything that I can update you with. Unfortunately, he's alone in his cell. He's a top one to pull his. Oh, okay, cool. Well, wasn't Sarah Boone having issues with the jail on how many boxes she had in her cell because it was a fire hazard or something like that? And somebody sent the man he said there's one pencil sharpener in the entire cell block, and if that gets broken, he's screwed. So someone posted him a pencil sharpener. Guard has come to toss his cell and confiscated a few of his things, and he wanted us to call the jail and make sure that it. Yeah, well, if you can get in touch with him, get in touch with him. It's not an easy process to do. It is quite detailed in what you have to set up, but yeah, I would love to have spoken to him. Love to. So, and you're welcome to, if you want to, if you've got a, if you ever wanted to come on and update us with some more info, Becca, just reach out to me. I'm on AJ's Discord as well. So, all right. Oh, yes, Grandma. Yes. I think she's got some stuff coming up either tonight or in the morning, hasn't she? I always bump into you, Gabby, over there. I think I beat you last time. Totally asked that. All righty. Well, thank you very, very much for joining me. It hasn't been the same. Oh, Kahoot tonight. Hasn't been the same without my side buddies. But nevertheless, he filed for a grievance and said he got a good. Drop that notion. What does that mean? Like for. Oh, okay. With Colleen Dunn, he needs to focus on one thing at a time. I think we can go after her after he's been acquitted and proven innocent. All right. With that, I am going to say bid you a good evening, or a good day, or good afternoon, whatever it shall be. It's lovely having you here, Flash fans. Good to see you. It's good to see you. Again, thank you for joining me. Now, it's Friday today. You guys have a public holiday on Monday, but I will be back. I'm going to, I got through, I think, the first 3 days of the first Treehouse murder trial before we had to start another trial. So AJ is taking Monday off to spend the day with her husband, and she has appointments Tuesday. So I will be doing the Treehouse murder trial, the first one, days 4 and 5 on Monday, Tuesday, and then Wednesday we'll be starting a fresh new trial. Yes, so that will be exciting. Be good. It's about a year old, this trial, but it's very interesting. And then there's a few good ones coming. We've got about a 2-week spot to fill before the next trial that we really, really want to get into, which is the Carly Gregg trial. And that starts on the 16th. So we miss you. So, yes. Why aren't you with your husband? Yes, she's left me. She's left me all on my own. Can I be trusted, Gabby? Can I? All right. So I will be back Monday. And with, as I said, Treehouse Murder. Tuesday, again, we're recapping that. And then Wednesday, new trial. Yes, we are. We certainly are. Don't you worry about that. All right. With that, thank you very much again for joining me, and I shall bid you adieu.
Covering true crime and police arrest, where the judges move and the defense rests. Watching courts and trials, criminals at best, where the gavel drops and the defense rests. If you love true crime and you want the best, won't you find the time and the defense